Your Stallions are in violation of Ridgeline Estates community standards. You have 14 days to remove them from the property, or we will pursue enforcement action." She said it the way someone says a thing they have said before or practiced saying, clipped, certain, the grammar of authority without the document to back it. She was standing at the gate of my south pasture in a blazer the color of slate, holding a clipboard with a printed form I could read from 10 feet away. I took the form. I read it. I folded it once along its center crease and put it in the breast pocket of my canvas jacket. What she did not know, what she could not have known, standing there at the edge of 5,500 acres of Wyoming grassland with her clipboard and her rehearsed certainty, was that the land beneath her feet, the road she had driven in on, the gate she had opened without asking, the fence posts along the entire western boundary of Ridgeline Estates, all of it sat inside a property line that had been mine, by deed, for 11 years, and my family's for 3 generations before that. I had not advertised that fact. I had not needed to. Drop a comment, tell me where you're from, and if something like this is ever happening to you, I want to hear it. The morning air carried the smell of sage and horse sweat and the faint mineral edge of the creek that ran along the north pasture boundary, and I stood there in it and listened until she finished speaking. Then I said, "Thank you for coming." She did not seem to know what to do with that. The land has a name. It has always had a name. My grandfather, Elias Cutter, called it Cutter Flats when he filed the original homestead claim in 1941, and the name stayed on the deed through 3 subsequent transfers, all of them within the family, all of them recorded in Teton County without interruption. My father, Raymond Cutter, ran cattle on the eastern half and dryland wheat on the northern quarter for 31 years. He was not a sentimental man, but he kept every document in a fireproof box in the back of his study: survey plats, grazing permits, water rights filings, tax receipts going back to 1943. And he told me once, when I was maybe 12 years old, that the paper was as important as the fence. "Anybody can cut a fence," he said. "You cannot cut a recorded deed." I inherited the ranch in full when my father died in 2012. He left it to me without condition, without trust structure, without any encumbrance beyond the existing agricultural water rights agreement with the county. The deed transferred clean. I had it recorded within the week, and I kept the original in the same fireproof box where my father had kept his, which was the same box his father had used before him. The box sat on the shelf in my study behind the door, next to a rolled plat map from the 1987 boundary survey that my father had commissioned after a neighbor tried to claim a strip along the eastern creek bed. That neighbor's claim had not survived contact with the survey. Most claims don't when the survey is clean. I had been running horses on Cutter Flats for 9 years by the time the woman in the slate blazer arrived at my gate. Quarter horses, primarily, working stock, bred for cattle work, not for show. I kept 14 mares and 3 stallions, all registered, all vaccinated, all documented with the Wyoming Livestock Board. The stallions were housed in a dedicated breeding facility on the southwestern corner of the property, a 3-stall barn with a covered run and a 2-acre turnout paddock that I had built myself over the course of one summer. The facility sat approximately 1,200 feet from the nearest Ridgeline Estates residential lot. It was not visible from any public road. Ridgeline Estates was a residential subdivision that had been developed on a 340-acre parcel carved out of the northeast corner of Cutter Flats in 1998. 6 years before my father sold that parcel to a developer named Harlan Voss. The sale was clean, properly recorded, and the boundary between the subdivision and the remaining ranch land was surveyed and staked at the time of the transaction. The Ridgeline Estates HOA had been formed in 2001 when the first homes were sold, and for 11 years after I inherited the ranch, they had operated without incident. Or rather, without incident that came to my door. The woman at my gate was named Diane Forsyth. She held the title of Community Standards Director for Ridgeline Estates HOA, a title she introduced herself with in full, as though the length of it conferred weight. She was not the board president. That was a man named Gerald Phelps, whom I had spoken to exactly once 2 years prior, about a fence repair along our shared boundary line. That conversation had been brief and unremarkable. Phelps had seemed like a reasonable man. I would revise that assessment later. The form Forsyth had handed me was a notice of violation, 1 page printed on HOA letterhead. It cited Section 4.2 of the Ridgeline Estates Community Standards Manual. Livestock and large animal restrictions, and stated that the presence of uncastrated male horses within the community's defined area of influence constituted a violation of that section. The fine was $750, due within 14 days. There was a second paragraph that stated, in language that was dense but not quite legal, that continued non-compliance could result in the HOA pursuing remediation through the county. I read that form 3 times that evening at the kitchen table, the fireproof box open beside me, and my father's rolled plat map, weighted flat with a coffee mug and a stone I had picked up from the creek bed years ago. The phrase that held my attention was community's defined area of influence. It appeared in the notice without citation, without a reference to any recorded document, without a section number from any instrument I could locate. It was not a legal term I recognized from Wyoming property law. It was not a term from the HOA's own CC&Rs, which I had downloaded from the county recorder's website within an hour of Forsyth's departure. The CC&Rs for Ridgeline Estates were recorded in 2001 and ran to 42 pages. Section 4.2 existed. It did restrict livestock and large animals. But the geographic scope of Section 4.2 was defined in the document's own language, in Article 1, Section 1.1, as applying to all lots and common areas within the Ridgeline Estates planned unit development as platted and recorded in Teton County Plat, Book 14, pages 88 through 91. I pulled up Plat Book 14 on the county's online records portal. Pages 88 through 91 showed the Ridgeline Estates subdivision boundary, 340 acres, 87 residential lots, 2 common areas. The boundary was drawn in black ink on the plat, clean and unambiguous. My breeding facility was not inside that boundary. It was not close to that boundary. The nearest point of my stallion paddock to the Ridgeline Estates plat line was, by my own measurement the following morning with a 300-foot tape, 1,187 feet. I did not call Forsyth. I did not call Phelps. I wrote nothing down on paper that night that I was not prepared to have read aloud in a county courtroom. What I did was make a list of documents I intended to obtain: the current survey of my property boundary, the recorded plat for Ridgeline Estates, the full title chain for the 340-acre parcel sold to Voss in 1998, and a certified copy of my deed. I already had most of them. I wanted certified copies of all of them. I also called my neighbor to the west, a man named Frank Aldridge, who had ranched his family's land since before I was born and who had, over the years, developed a particular interest in the property records of this county. Frank was 73 years old and had the memory of a land surveyor and the disposition of a man who had been wronged once and decided never to be wronged again without documentation. He had watched the Ridgeline Estates development go in from his fence line, and he had opinions about Harlan Voss and about the HOA that he had shared with me in pieces over the years. "They sent you a notice," Frank said when I told him. It was not a question. "1 page," I said. $750. There was a pause on the line, the kind Frank used when he was arranging something in his mind. "They sent the Kellerman place one of those 2 years ago," he said. "Kellerman's just paid it. Didn't know they didn't have to." I thanked Frank and told him I would be in touch. Then I went back to the kitchen table, to the plat map and the fireproof box, and I sat with the documents until the kitchen light was the only light on in the house, and the horses were quiet in the dark outside, and the only sound was the creek running over the stones my grandfather had walked beside before I was born. The 14-day clock was running. I was not in a hurry. The certified letter from Ridgeline Estates HOA arrived on the 4th day after Forsyth's visit. It was signed by Gerald Phelps in his capacity as board president, and it restated the violation notice in more formal language, adding that the board had voted at a special session to authorize enforcement proceedings if the Stallions were not removed or rendered compliant, a phrase I read twice, within the original 14-day window. The letter cited Wyoming Statute 3436-101 in a footnote, which governs planned community associations, but the citation was incomplete. It referenced the statute number without a subsection, and when I pulled the full text of 3436-101, I found that it governed the formation and governance of homeowners associations, not their extraterritorial enforcement authority. It said nothing about a community's capacity to regulate land outside its own recorded plat. I printed the statute. I highlighted the relevant sections. I placed it in a manila folder behind the HOA's 2 letters. The folder went into a larger accordion file I had labeled simply with the year and the word Ridgeline. The accordion file went on the shelf next to the fireproof box. On the 6th day, I drove to the Teton County Courthouse and sat at the public records terminal for 2 hours. I pulled the full title chain on the 340-acre parcel, every instrument recorded against it from the original 1998 deed forward. I pulled the plat map in its certified form. I ordered a certified copy of my own deed, the one recorded in 2012 when I inherited the ranch, and a certified copy of the 1987 boundary survey my father had commissioned. The county clerk, a woman named Rosalind, who had worked that office for longer than I had owned the ranch, printed everything without comment and handed me a receipt for the certification fees. I also asked Rosalind, without elaborating on why, whether there were any recorded instruments, easements, covenants, deed restrictions, or otherwise, that ran from the Ridgeline Estates plat onto the adjacent Cutter Flats parcel. She checked the index. She checked it twice. She looked up at me over her reading glasses with the flat expression of someone delivering an answer they have delivered before. "Nothing recorded," she said. "Nothing recorded. I wrote that in my notes verbatim, with the date and the time. On the 8th day, I called a land use attorney in Jackson named Patricia Okafor. I had used her once before, 3 years earlier, on a water rights question, and I had found her to be precise in the way that useful people are precise. She did not speculate, she did not reassure, and she did not bill hours she had not earned. I told her the situation in sequence: the notice, the letter, the CCNRs, the plat, the county records search. She listened without interrupting. When I finished, she was quiet for a moment. They have no recorded instrument extending their authority beyond the plat boundary, she said. Correct, I said. And your facility is how far from the plat line? 1,187 feet. Another pause. Send me everything, she said. The deed, the plat, the CCNRs, the 2 letters, and your notes from the county records search. I want to look at the title chain on the 1998 sale as well. I sent everything that afternoon. The documents arrived at her office in Jackson by courier the following morning, organized in the order she had requested, each one tabbed and labeled. Patricia called me 2 days later. Her voice carried the particular quality of a person who has found exactly what they expected to find and is not surprised but is nonetheless interested. The CCNRs are unambiguous, she said. Article 1, Section 1.1 limits the covenant's reach to the recorded plat. There is no recorded easement, no deed restriction, no annexation instrument of any kind that extends HOA authority onto your property. Their notice has no legal foundation. I said I had read it the same way. I'd like to send them a letter, Patricia said. Give me a few more days first, I said. I want the survey updated. I'd already called the surveying firm my father had used in 1987. They were still in business, operating under a second generation, and scheduled a boundary survey of the full ranch perimeter, with particular attention to the corner monuments adjacent to the Ridgeline Estates plat line. The survey crew came out on the 11th day. They worked for 6 hours. They found all 4 corner monuments intact, undisturbed, consistent with the 1987 survey and with the legal description in my deed. The survey report arrived in my email on the 13th day, the day before the HOA's deadline. The boundary was exactly where the deed said it was. The Stallion facility was exactly where I knew it to be. The distance from the nearest HOA plat line to the nearest point of my paddock fence was 1,191 feet. 4 feet more than my tape measure had shown, because the survey used the recorded monument rather than the fence post I had measured from. I forwarded the survey report to Patricia that evening. The 14-day deadline passed quietly. The horses were in the paddock at dusk, the 3 stallions moving along the fence line in the long horizontal light, their breath visible in the cooling air. I watched them from the gate for a while the way my father used to watch his cattle at the end of a working day, not counting them exactly, just confirming the fact of them. The land was still mine. It had always been mine. That had not changed. Patricia's letter went out on the 16th day, 2 days after the HOA's deadline had passed without any action on my part, and without any further communication from Forsyth or Phelps. The letter was 4 pages long, single-spaced, printed on her firm's letterhead, and sent by certified mail to the Ridgeline Estates HOA Board at the address listed in their recorded CCNRs. I had read a draft the evening before she sent it, sitting at the kitchen table with the accordion file open beside me, and the creek running audibly through the window I had left cracked against the warm night air. The letter was precise in the way that documents prepared by careful people are precise. It named every instrument by its recording number. It cited Article 1, Section 1.1 of the CC&Rs verbatim. It referenced the updated boundary survey by its date and the name of the licensed surveyor who had signed it. And it stated, in language that did not leave room for interpretation, that the Ridgeline Estates HOA possessed no recorded instrument of any kind extending its authority or its covenants to the Cutter Flats parcel, and that the notice of violation issued on the date of Forsyth's visit was without legal foundation. The operative sentence, the one I read twice and then a third time, was near the bottom of the second page. It read, "My client hereby demands that the Ridgeline Estates Homeowners Association retract the notice of violation in writing. Cease all further enforcement communications directed at land outside the recorded plat boundary of Ridgeline Estates as described in Teton County Plat Book 14, pages 88 through 91. And provide written confirmation of Sam within 10 business days of the date of this letter." I had not asked Patricia to include a demand for costs. Not yet. I wanted to see what the board did with a clean, documented request before I asked for anything further. That was a decision I would revisit. The certified mail receipt came back signed on the 19th day. I added it to the accordion file. Frank Aldridge called me the following week. He had heard, through whatever channel Frank used to hear things about the Ridgeline Estates Board, that there had been a meeting. He did not know what had been said at the meeting, but he knew that Gerald Phelps had been on the phone with someone in Jackson for the better part of an afternoon, and that Diane Forsyth had not been present. Frank delivered this information in the same flat, unhurried tone he used for everything. The way a man delivers facts, he is verified and sees no reason to dramatize. I thanked him and made a note. The 10 business days passed. No written retraction arrived. What arrived instead, on the 23rd day from Patricia's letter, was a response from an attorney. A man named Douglas Farwell, whose letterhead identified him as practicing in the area of community association law out of a firm in Cheyenne. The letter was 3 pages. It opened by asserting that the Ridgeline Estates HOA had a legitimate interest in the character and use of land adjacent to the subdivision, citing a general principle of community welfare that Farwell did not connect to any specific recorded instrument. It then argued that the Stallions constituted a nuisance under Wyoming common law, citing a case from 1974 that involved a feedlot operation within a municipality, a case that bore no meaningful resemblance to a licensed breeding facility on private agricultural land in a rural county. The letter closed by suggesting that both parties would benefit from a mediated resolution and that the HOA remained open to a conversation. I read Farwell's letter twice. It was, in the technical sense, a response. It was not a retraction. It did not cite a single recorded instrument extending HOA authority onto my land, because no such instrument existed to cite. What it did was reframe the question, move it from property law, where the record was clear, to nuisance law, where the argument was at least theoretically arguable, though not well argued here. I recognized the maneuver. It was the kind of letter a lawyer writes when the client's position has no foundation in the relevant documents, but the client is not yet ready to hear that. I forwarded it to Patricia without comment. She called me that afternoon. "He cited Hansen versus the city of Laramie," she said. "That case involved a commercial feedlot inside city limits. Your Stallions are on agricultural land zoned for exactly this use, 1,100 feet from the nearest residential lot line." "I know. I said. He's also ignoring the threshold question entirely, she said, which is whether the HOA has any standing to bring a nuisance claim against land it has no legal relationship to. You can't assert nuisance against a neighbor's agricultural use unless you have a property interest that the use is affecting. The CC&Rs don't create that interest. They're internal to the plat. I asked her what she recommended. File in district court, she said. Declaratory judgment. You're asking the court to declare that the Ridgeline Estate CC&Rs do not apply to your property, and that the HOA has no authority to enforce them against you. It's a clean question. The record answers it. I told her to file. She had the complaint drafted within 4 days. It was 7 pages, attached exhibits running to 43 pages. The deed, the plat, the CC&Rs, the boundary survey, the 2 HOA letters, Patricia's demand letter, Farwell's response, and the county record search results, including Rosalind's notation that no instrument had been recorded extending HOA authority onto the Cutter Flats parcel. The complaint was filed in Teton County District Court on a Tuesday morning. The filing fee was $420. I paid it without hesitation. The case number was assigned the same day. I wrote it on the inside cover of the accordion file. What happened next took time, the way legal proceedings always take time when one side has paper and the other side has a theory. Farwell filed an answer on behalf of the HOA, which largely restated the nuisance argument and added a new claim. That the 1998 sale of the 340-acre parcel to Harlan Voss had included an implied covenant running with the land that obligated adjacent property owners to maintain compatibility with the residential character of the subdivision. The word implied appeared 3 times in the answer. The word recorded did not appear once in connection with that covenant. Patricia filed a motion for summary judgment 6 weeks after the complaint. The motion was supported by a brief that ran to 22 pages, and that I read in full the evening it was filed at the kitchen table. The plat map waited open beside me, the fireproof box within arm's reach. The brief's central argument was uncomplicated, stated in the opening paragraph and supported by everything that followed. The CC&Rs were a recorded instrument with a defined geographic scope. That scope was the Ridgeline Estates plat. The plat did not include the Cutter Flats parcel. No other recorded instrument extended HOA authority beyond the plat, and therefore the HOA's enforcement action had no legal foundation as a matter of law, without any disputed fact requiring a trial. The brief cited Wyoming Statute 3436-101 in full, all subsections, not just the number, and quoted the relevant language directly, that a planned community association's authority was limited to the common interest community as described in the declaration and the recorded plat, and that no association could exercise enforcement authority over real property not included within that description, absent a recorded instrument expressly granting such authority. It was the same statute the HOA had cited in its second letter to me, the one signed by Phelps. They had cited it as though it supported their position. Read in full, it did the opposite. That was, as Patricia noted in a brief call after filing, one of her favorite pieces of evidence in the entire file. The HOA had handed it to us. The discovery period that followed was not dramatic. Farwell requested documents. Patricia produced them, all of them, organized, tabbed, Bates stamped. We requested documents from the HOA. What came back was a thin production, board meeting minutes, correspondence files, a copy of the CCNRs we already had, and a series of internal emails between Phelps and Forsyth that I read carefully and placed in a new section of the accordion file. The emails were not incriminating in any criminal sense. They were something quieter than that. They showed that Phelps had been aware, as early as 2 months before Forsyth's visit to my gate, that the Stallion facility was outside the plat boundary. There was an email from Forsyth to Phelps, dated 8 weeks before the notice, in which she wrote, "I pulled the plat. The cutter operation is technically outside our boundary. Do we still have a basis?" Phelps had replied the following day, "Our CCNRs say community character. That's broad enough. Send the notice." I read that exchange 3 times. I was not angry. I want to be clear about that. What I felt was something closer to the quiet satisfaction of a surveyor who has walked a boundary and found every monument exactly where the record said it would be. Phelps had known. He had made a decision anyway. The document that recorded that decision was now in my accordion file, Bates stamped, produced in discovery, available to the court. The paper had done what paper does when it is kept carefully and produced completely. It had told the truth. The summary judgment hearing was set for a Thursday morning in late autumn in a courtroom on the 2nd floor of the Teton County Courthouse, the same building where Rosalind had printed my certified documents months before, the same building where my father's deed had been recorded in 1978 and mine in 2012. The courtroom smelled of old wood and heating system dust, and the particular stillness of a room that is used for serious things and knows it. I arrived 20 minutes early. Patricia was already there, her file open on the counsel table, her pen moving in small, deliberate marks on a yellow legal pad. I sat in the gallery and watched the light come through the tall windows and thought about my grandfather walking the boundary of this land before the courthouse had been built, before the plat existed, before any of the instruments in my accordion file had been drafted or recorded or filed. Elias Cutter had earned this land with his hands and his years and his willingness to stay when staying was hard. He had not anticipated that his grandson would one day need to defend it in a courtroom against a homeowners association that had sent a notice to a property it had never legally touched. But he had kept records. He had filed documents. He had understood, in the way that people who work close to the land tend to understand, that the paper was as important as the fence. I had not forgotten that. Gerald Phelps was present, seated at the defense table beside Farwell in a dark jacket and a careful expression. Diane Forsyth was not there. I did not know whether she had been asked not to come or had chosen not to, and I did not spend time wondering about it. The judge was a woman named the Honorable Catherine Marsh, who had been on the district court bench for 14 years and who, when she entered the room and took her seat, had the composed, unhurried manner of a person who has read the briefs and has already formed a view. She had read the briefs. That was clear within the first few minutes of the hearing. She asked Farwell 2 questions, pointed, specific, document-referenced questions about the implied covenant argument and the basis for the nuisance claim, and Farwell's answers, which were careful and not unintelligent, did not point to a single recorded instrument, because there was none to point to. Judge Marsh listened to both sides fully. She did not interrupt Patricia's argument. She did not need to ask Patricia many questions because the brief had answered them. The hearing lasted 47 minutes. Judge Marsh took the matter under advisement and issued her written ruling 11 days later. It was 12 pages. I read it at the kitchen table on the morning it arrived. The accordion file open, the plat map weighted flat, the fireproof box on the shelf behind me where it had always been. The ruling granted summary judgment in my favor on all counts. It found, as a matter of law, that the Ridgeline Estates CCNRs applied exclusively to the lots and common areas within the recorded plat as described in Teton County Plat Book 14, pages 88 through 91. It found that no recorded instrument extended HOA authority to the Cutter Flats parcel. It found that the HOA's notice of violation and subsequent enforcement communications were without legal foundation. And it ordered the Ridgeline Estates HOA to pay my attorney's fees and costs, pursuant to Wyoming Statute 3436-121, which provides for fee shifting in cases where a homeowners association brings or maintains an action without a reasonable legal basis. The fee award totaled $14,640. The ruling was recorded in the Teton County Court records the same day it was issued. It would remain there, indexed against the Ridgeline Estates HOA, for anyone who cared to look. The record, as my father had once told me, does not forget. Patricia called me the morning after the ruling arrived to confirm that the fee award had been formally entered and that the HOA's window to appeal was running. She did not celebrate over the phone. That was not her way, and it was not mine. She said the ruling was clean, that Judge Marsh had written it in language that would be difficult to distinguish on appeal, and that she did not expect Farwell to file one. I asked her why. Because an appeal requires a colorable argument, she said, and there is no recorded instrument. There never was. Farwell knows that now, if he didn't know it when he filed the answer. I thanked her. She said she would send the final invoice and that it would reflect the offset from the fee award. I told her I would look for it. We said goodbye the way people say goodbye when the work is finished, and it was done correctly. The HOA paid the fee award in full. The check arrived at Patricia's office 31 days after the ruling, drawn on the Ridgeline Estates HOA operating account for $14,640. Patricia forwarded me a copy of the check image with a single line of text in the email body, "Received." I printed it, folded it once along its center crease, and placed it in the accordion file behind the ruling. The accordion file was full by then. I'd started it with a single printed notice on HOA letterhead, and I was closing it with a district court ruling, a fee award, and a check that represented the full arithmetic of Phelps's decision to send Forsyth to my gate with a clipboard and a rehearsed certainty she had no legal foundation to carry. I did not call Phelps. I did not write to Forsyth. There was nothing left to say that the record had not already said more clearly than I could have said it. Frank Aldridge came by the following week on a Tuesday afternoon when the light was low and golden across the pasture, and the sage was giving off that dry, resinous smell that it carries in the weeks before the first hard frost. He pulled his truck up to the south gate, the same gate where Forsyth had stood in her slate blazer, and we leaned against the fence rail and watched the horses in the far paddock. The 3 stallions were moving along the fence line the way they always moved in the late afternoon, unhurried, following some internal logic of territory and habit that had nothing to do with the proceedings of the Teton County District Court. Frank had heard about the ruling through whatever channel Frank used to hear such things. He did not ask for details. He just said, "You kept the paper." And I said, "My father kept it first." And Frank nodded as though that settled something he had already known. He told me, before he left, that the Kellerman family had heard about the case, the Kellermans, the ones Frank had mentioned months earlier, the ones who had paid the HOA's notice 2 years prior without knowing they didn't have to, had spoken to a lawyer of their own. I did not know what would come of that, and it was not my concern. What they did with their own records and their own rights was their business. I had only ever been responsible for mine. The Ridgeline Estates HOA board held a special meeting 3 weeks after the fee award was paid. I learned about it from Frank, who had learned about it from a woman who lived on the eastern edge of the subdivision and attended every board meeting with the focused attention of someone who had been burned once by a vote she had not witnessed. At that meeting, Gerald Phelps announced his resignation from the board presidency. The announcement was, by the account Frank relayed to me, brief and without elaboration. Phelps cited personal reasons. Diane Forsyth had already stepped down from the Community Standards Director position 2 weeks earlier, quietly, without a meeting or a formal announcement. The board elected an interim president from among the remaining members. I did not know the interim president's name and did not seek to learn it. What I knew was that the ruling was recorded in the county court records, indexed against the Ridgeline Estates HOA, and that it would remain there for any future board member, any future buyer of a Ridgeline lot, any future attorney reviewing the HOA's history of enforcement actions to find. The record does not expire. It does not soften with time. It sits in the index exactly as it was filed, and anyone who looks will find it. That was enough. On a morning in early November, after the first frost had come and gone and left the grass silver at the edges and the creek running clear and cold over the stones, I walked the south boundary of the property, not for any legal purpose, not to measure or document or photograph. I walked it because my grandfather had walked it, and my father had walked it, and walking it was one of the ways I understood that the land was still mine and still whole. The fence posts along the western boundary were cedar, the same species my grandfather had used, though not the same posts. I had replaced them twice over the years, cutting new posts from cedar rounds I bought from a mill in the valley, and sat in them in the same holes, or close to the same holes, that the original posts had occupied. The wire was tight, the monuments were undisturbed. The corner markers that the survey crew had confirmed in the 11th day of all of this were exactly where they had always been, exactly where the deed said they were, exactly where Elias Cutter had first walked the line and understood that the land was his to keep if he kept it correctly. I stood at the southwest corner for a while where the fence line meets the creek and the water runs shallow over a flat shelf of limestone that my father used to fish from when he was a young man. The mallards were working the creek bend upstream the way they work it every autumn, unhurried and indifferent to everything that had happened in the months since Forsyth had stood at my gate with her clipboard. The sage smelled the way it always smells in November, drier, sharper, carrying the cold in it. The horses were audible from the south paddock, a half-mile back, the low percussion of hooves on frozen ground. The land had not changed. It had never been in any real danger of changing. What had been in danger was the clarity of who had authority over it, and that question had been answered, not by me, not by Patricia, not by Frank Aldridge or Rosalind at the county clerk's desk, but by the record itself, by the plat in Plat Book 14, by the deed recorded in 2012, by Article 1, Section 1.1 of the CC&Rs that the HOA had written, recorded, and then apparently never read closely enough to understand the limits it placed on their own authority. The lesson, if there is one, is not complicated. When an institution with apparent authority makes a claim against you, when the letter arrives, when the notice is served, when the person with the clipboard and the rehearsed certainty appears at your gate. The first question is not whether they seem confident, and it is not whether their letterhead is official, and it is not whether the fine they are threatening is large enough to make compliance feel easier than resistance. The first question is whether their claim has a legal foundation, and the answer to that question is always in the record. It is in the deed. It is in the plat. It is in the county index. It is in the instrument, or in the absence of one. It has been there the whole time, waiting for someone to look. My father understood that. His father understood it before him. I'd learned it the way I had learned most things about this land, slowly, by watching men who knew it, and by keeping the paper they had kept before me. I turned and walked back along the fence line toward the barn, the frost crunching lightly under my boots, the creek sound fading behind me as I moved north. The accordion file was on the shelf in my study, closed now, beside the fireproof box that had held the deed through 3 generations of this family's life on this land. The plat map was rolled and stored. The horses were in the paddock. The boundary was where it had always been. Nothing had changed. That was the whole point. Nothing had ever needed to. If any of this sounds familiar, if you have a fence line someone is questioning, or a notice that arrived without a legal foundation, or a deed you have not looked at in years, I would be glad to hear about it in the comments. And if you want to follow along for the next case, which involves a different kind of boundary dispute and a different kind of paper trail, it is worth staying close.